Hello everyone, I am Hemang Shah. So I'm welcoming you
Good
today as
afternoon, everyone. Hello.
good yes, good afternoon.
Good afternoon, everyone.
Yes. Uh, Thank you all for joining us today. I am Hemang Shah. I'm the co-chair for the National IPR Council at ASSOCHAM, and I also lead the Qualcomm Innovation Lab, where we have been incubating startups since 2016. Before we get started today, we just thought of providing a brief overview about L2 Pro. It's a completely free IP e-learning program designed for startups, entrepreneurs, and working professionals. It's available on Play Store, App Store, and web. And the pain point that this particular program is solving is when we were working with startups, we realized that they had a lot of questions on intellectual property. And when you interface them with an IP professional, those questions were answered. But what happens when these people are not in front of them? Which is everyday life, right? When you are working in your lab, when you're working in your office, what information do you look up to? So we discussed these observations with DPIIT and NLU Delhi, and this program L2 Pro was initiated. Pradeep Kumarji, can you please mute? Thank you. So the course material is split across different modules, which I'll discuss. Now, the goal for L2 Pro is to help everyone understand how to protect innovations with patents. Uh, Sumit Pratapji, please mute yourself. Thank you. How to use copyrights to protect software, how to develop trademarks, how to build IP considerations into business models, essentially how you work on R&D efforts and bring your innovations quickly to market. The three modules are basic, intermediate, and advanced, where you'll walk through the different aspects of IPR. Now, because this course has been written for startups and entrepreneurs, we made sure that the language or the way the information is presented is in an interactive manner, easy to look up. So you will see, pop-up quizzes. You will see resources which will be there. You will see interesting elements being highlighted. There are with every lesson, uh, there is an introductory video and a summary video. So you have roughly a 2 minute intro video and a similar duration summary video. So in my opinion, in 5 minutes, you can learn most of the material from that lesson. And for the further details, you have to go through the different slides that you're seeing on the screen. The best part is that the assessment is based on a case study. These are situations which startup is going to encounter. Uh, Manika, Marshiji, please mute yourselves. Thank you. Now, the assessments are based on case studies, a situation that a startup is going to encounter in their everyday life. And so, if you complete that assessment successfully, you get a certificate which is generated on the spot. And this certificate is provided by DPIIT, CPAM, NLU Delhi, and Qualcomm. So we've already played the intro video. So I think having said that, let's dive into the heart of today's session, which will be presented by Mr. Vijaykumar Shivpuje. And before I invite Vijay, I'd like to just briefly introduce him to all of you. Vijaykumar Shivpuje is a director at Patlex Business Solution. It's a knowledge process outsourcing firm practicing in patents and designs. He's an IPR lead at the IP Facilitation Center, ASSOCHAM. He's a mentor with Niti Aayog Atal Tinkering Labs and with Startup India. He's a co-founder for Pharma Literati and Initiative for Online Pharma Education. Vijay is a registered patent agent at the India Patent Office. He has conducted 100 plus IPR awareness programs across universities, colleges, bar association, incubation centers. Name it, he has done a workshop there. Very interestingly, just a couple of days ago, the India Patent Agent examination results were released. And Mr. Vijay has trained these patent agent aspirations. And for the year 2022, 60 of his students have qualified to be patent agents. That's an amazingly impressive feat. Congratulations, Vijay. We are looking forward to hear from you. And now I'll turn the floor over to you, Vijay.
Thank you. Thank you so much, Hemang. A very good afternoon to everyone. Just to confirm if I'm clearly audible.
You are.
Sure.
Yeah.
A little louder, actually.
Yeah, you can.
Yeah.
Go ahead.
Slow.
Okay. So good afternoon, everyone. All the dignitaries present over here, the participants as well as the functionaries from ASSOCHAM. I'm delighted to be here for the first session of mine with L2 Pro, the platform that just Hemang mentioned, the learn to protect, secure, and maximize your innovations. Honestly speaking, I've been working, as Hemang mentioned, about the startups, entrepreneurs, individuals, universities, and all. Since almost last 5.5 years, I've been working with various stakeholders to protect their inventions or innovations, specifically with the Indian Patent Office. This is across the domain actually. And to tell about my journey a bit, in 5 years, we have got almost 200 plus patent applications filed, most of them coming from life sciences domain as such. And but then one major change or shift that we have seen in last few years is with respect to those things that happened, I would say, in last few years. Actually, two things have majorly changed the innovation ecosystem in India, and every one of us would definitely agree on that. Since I work in the life sciences domain, the first thing that actually have changed the innovation ecosystem, I would say, is the COVID-19. The way we used to think, the way we used to innovate in pre-COVID time and now post-COVID is really very different actually. Like, that has really changed or boosted a lot of industries, including the research-based industries in innovation. And the second change that actually happened all across India, I would say, is because of one simple program that every one of us, almost every one of us, watched last year. That was Shark Tank India. Like 20 साल 22 साल के बच्चे आके, when they are thinking about the investments, the the ideas, the protection for that, and getting funding for that, and getting coverage all across the national television actually. And if you see, they were just not from the first year or the first year cities, or they were not just from the IITs or NIPERs or ICTs and all, but we have seen that a lot of innovations happening from the rural areas as well as second, third tier institutions as well were highlighted during that specific program. And so and if we look at the different programs or the the kind of opportunities government has also come up with, be it a Make in India program, Startup India program, or any other programs that we have actually, the government is also focusing or promoting on the innovation side actually. These are very small steps taken in the right direction, I would say. And most of the especially those who have joined in for the academics, for them for sure, the real change or the real requirement of innovation is all because of let me be a bit blunt, but बहुत सारा innovation is happening in India just because of the accreditations that we require for the NAC or NBA or the so-called NIRF rankings or ARIA actually, but these are small steps in the right direction, wherein the innovation ecosystem is actually taking us to the next level actually. And when we think of all these things, one of the most significant or important aspect is with respect to protecting that innovation actually. And we have been doing ASSOCHAM as a chamber, or programs like L2 Pro have been doing a lot of awareness related activities all across India, which is actually helping in terms of protecting the innovation, right kind of innovations, I would say. And of course, there are a lot of advantages of protecting these innovations. I'm going to specifically speak about the patent registration procedures in India, because that's the topic that has been allotted to me in this particular series of, I would say, webinars that ASSOCHAM would be conducting for the L2 Pro platform as such. And it is very I would say good to start with the very basics or fundamentals and the first kind of IP, that is patent, because patent is the one which has got maximum visibility, I would say. And maybe because of the movie Three Idiots or other. Generally, IPR, intellectual property rights, is kind of synonymously used with patents as such. But then that's not the case. As Hemang mentioned, there are multiple types of intellectual property rights actually. It is very essential for everyone to understand that what is the right kind of IP for your innovation or invention, because it may not be only patent, for a tech based startup. It may also be with respect to something related to copyright or integrated circuit designs or the industrial design, or of course for every business it may be trademark as well. It is very essential to understand what is the right kind of IP for your kind of innovation. And if you can answer this question, or if you can understand this, then the entire process of innovation or the protection of innovation becomes really very easy as such. And presuming that each one of us at least know what are the different types of IP, and patent is just one of them. I'll be speaking more about the patent registration procedure in specifically in the context of India. Of course, it's a big topic for every country, or for PCTs or regional patents. We can have separate sessions, but let me share my screen and start with the actual presentation, what I'll be speaking today about the patent registration procedures as such. Okay, just to confirm, is my screen visible?
Yes.
Yes, sir.
Yeah, we can
Yeah,
see it. Yeah, go
thank
ahead.
you. Okay, here comes a scientist, a student, a faculty, a researcher, and the end goal is to protect the invention or innovation actually. As a patent attorney or as a patent agent, my job is to ensure that you are getting this kind of certificate, which is by Government of India. Not only the certificate, but also the protection, legal protection for your invention. The way we the What do you mean by actually the legal protection? Actually, it's about the ownership of that idea or the concept actually. At the moment we think of ownership, when I have this iPhone in my hand, I can say that I own this basically. And I can say that just because of the receipt that I have got, payment receipt, when I actually bought this particular iPhone. That's how it is proven that, or it is like a legal proof basically that I own the iPhone. Something similar. What about those ideas that are happening, that the research that you are doing in your labs basically, be it coming from the engineering domain. I saw some people from biochemistry, biotechnology, or life sciences. Any idea or any concept, what we call it is a hypothesis, that is actually work, that we feel is going to work. It's gonna create some kind of business value as well, not only for you but also for the country. It is going to help the people as well. There is some business value associated with that point of time. You would definitely want to protect it legally. That means the idea is owned by you actually. The idea is owned by you actually. And when that idea is owned by you, that is actually provided by something called as a patent, the granted patent, a certificate that I have got it here for you actually. I'll be taking you through this entire process of from your brain, the idea, the hypothesis, till the grant of the patent as such. And I have got this snake and ladder actually, the simple game that we have been actually playing. And for me, as a patent agent or a professional, it's always a snake and ladder from idea to the patent grant actually. How we'll try to understand it in very simple terminologies actually, as we know, we have a lot of snakes here and a lot of ladders here. Snakes for me are the, I would say, the red spots which we need to avoid, as a scientist. And the ladders are the ones which are the plus points, or which can help you, or I would say facilitate you to get the patent granted very easily. What are these snakes and ladder? I'll let you know in very simple terms actually, the first one, And of course, each one of us know this, that the invention has to be novel. That is one of the major requirements as such, like, with respect to getting a patent granted, like, now, what do you mean by novelty? Most of the times when a startup or when a professor comes to us, they tell us, sir, this product is not available in India. I want a patent in India, actually. This product may be available in US or Japan or some other market, but I'm the first one in India who will be launching this product actually. Now that's not research, honestly speaking. That's not novel. The concept of novelty is absolute novelty. That means if you have got an invention, you may get the right only for a country, but the invention has to be novel globally. And when I say globally, it need not be only the English language, but any other languages as well, be Japanese, Korean, Chinese, French, Spanish, anywhere. If that invention is disclosed, then it is not considered as a novel invention. And how is that novelty calculated? Novelty is determined basically just before the day you file your first patent application. That means if I am filing a patent application on 3rd August 2022, anything that is in public domain, in any language, in any form, basically, like, that is considered as a prior art for you, and your invention is not novel if it is available in the public domain. Now, what are the problems actually, I would say, or what are those things that we do which may kill the novelty? That we'll see actually through some of these snacks as well later. But then another, if your invention is novel, then you have got a, I would say, a plus point, and you can actually get your invention granted as well. The second step, or the second ladder that I have got, is the inventive step actually. What do you mean by inventive step? Something that is novel, let me tell you a simple example, and that's how I would call it research in India, incremental innovation happens. I've got these two separate things. What I do is, these are known at different places basically. I just club them so that joining them together, okay, is happening for the first time, let us say, across the world. So there are two components, there are two components, and those two components are not available at one place. May be a research paper, or may be any kind of publication basically. When they are available in two different places, but it is very predictable to combine them, that means it would give you the effect actually. So in that case, the invention is considered as a predictable. That means it doesn't have got any inventive step basically. Now, there is a major difference between novelty and inventive step also. I'll tell you this with a very simple example as such. So let us presume we have got two different products which have got nutritional value. There is component A which has got nutritional value, component B which has got a nutritional value. When you combine these two, definitely there can be some kind of nutritional value associated with that would be there with the end product, the combination basically. Right, so that's quite something, I would say, predictable. That the moment it is predictable, there is no inventive step. For me, the word non-obviousness, which is an alternative for inventive step, means unpredictability of the art. The result, the end goals that you are getting, are they predictable? If they are unpredictable, at that point of time, you can get that invention, because this is a major step, or the second criteria for getting a patent granted as such. The third one is industrial use, one of the simplest, I would say, requirements. Any product or a process which is prepared by the industry or for the industry. In that case, it is something which would be giving, I would say, the industrial applicability for the product. Many times we get a lot of queries from people from maths, physics. We have come up with this theorem, we have come up with this law kind of stuff, which is really helpful. Now, as long as there is no industrial application for that, it cannot be patented per se. Now, industrial use is the process actually, or the requirement basically, which is that's the reason the patent rights are also called as industrial property rights. These are meant for the industries actually. So it can be any product either prepared by the industry or prepared for the industry. If you have these three major criteria satisfied, then for sure your invention has got something to do. I would say it can get very easily granted as such. And these are the common criteria provided by trips to every country. So if you have these criteria satisfied, in that case you can have your invention getting granted. But then there are a lot of snakes here as well. Let me tell you, uh, the major flaw with I would say with the mostly with the startup ecosystem or the academic ecosystem is that they still believe in the research paper or publications. Actually, not only research paper or publications, but beyond that, you at some point of time you have that eureka moment, let's say, of doing that research basically for that product. You are so happy that you are sharing it on Instagram, you are sharing it on your Facebook account, you are sharing it on LinkedIn. Actually, this had actually happened. Actually, this had happened with some of our clients as well. They shared it on LinkedIn just to get some branding, I would say. Or at times you are sharing it in a newspaper, you are sharing it in a conference, you are publishing it basically. Remember, if you are publishing your research before patent filing, that's a big blunder that we are doing. The very first thing we have to do is file a patent, and thereafter you can publish it. Before filing a patent, if you are publishing, that's a big no actually, and there would be a lot of hurdles with respect to getting that patent granted as. This is the first and major, I would say, hurdle to get a patent granted. The next one is a prior arts, basically, what we call as a prior art. What is available, what what is available in the public domain before you. It's just not about your publications, but third party publications as well. Anyone else, at the end of the day, it may happen that many people are working on the same research, same product basically. If someone else publishes it before you, he's not patenting, he's publishing. Then also it is killing the novelty, and you won't get a patent for that actually. So novelty is absolute, not necessary you are publishing it. If third party is also publishing, that means you won't get a patent for that also. The next one is, I would say, and a very important one. I get a lot of inquiries wherein this is specifically for startups and again the universities actually. What happens, just of course at the early stage we have to be very cost conscious as such. I'm also running a startup, I know the problems startups face actually, and I'm also involved with a lot of universities as such, I would say, and academic institutions, the kind of funding problems we have. And because of that, what we try to do is we try to draft a patent application on our own. It is perfectly fine. Indian Patent Office legally allows you to draft patent, you to file a patent application. And most of us think it's like a research paper. Absolutely fine. It's a technical document only. But remember that this patent document is not a purely technical document. It is techno legal document, and that's where the skills of patent drafting, specifically claim drafting, is very significant as such. And if you are actually drafting your own patent, probably then you are not getting that patent granted as such, because of the kind of requirements patent office, not only I would say the administrative requirement as such, the procedural requirement, also with respect to the technical requirements as well. So this is a big no actually. If you are drafting your I would say own patent, because you can draft it really well as a technical document, not as a techno legal document. Remember, patent is a techno legal document. Next one, and the biggest threat for getting a patent granted, is section 3. There are certain inventions there are certain inventions basically which are not patentable as per the Indian Patent Act, and Section 3 actually of Indian Patent Act provides the entire list of those inventions. Typically for the life sciences industry to which I belong to, we have Section 3D, which doesn't allow a new form of known substance. We have Section 3 which doesn't allow the kind of combinations. Basically the 3I diagnostic therapeutic methods are not allowed. In case of 3P, the traditional knowledge basically is not something which is allowed us. So we have a lot of subsections under Section 3. We have to ensure that our invention doesn't fall under these all sections actually, I would say. Okay, now if your invention is novel, it is inventive, it has an inventive step which is also called as non-obviousness. Actually globally it is called as non-obviousness. We have this term inventive step. If it is has an industrial use, actually that point of time your invention can get granted, provided you are not disclosing it, there is no prior art available for it, you are it doesn't come under the Section 3 requirement as such, and you have drafted it really well. I have got one specific ladder that is left here, and like most of the times people don't give so much significance to this particular ladder, but I'll put it here. That's my name. I have actually put it here. Why I have put it here? The reason being is that remember that at times it is just not about drafting a patent or prosecuting it. It is very essential that you understand the technology first. If an invention from electronics or telecommunication domain comes to me, I may not be in a although I am allowed legally to file a patent application for that, but still I may not be in a position to understand the invention. That point of time I should not actually ideally do it, because I may not be in a position to do justice to that invention actually. Now when you go for an agent or attorney, what you can simply check is whether the agent or attorney understands your invention, because at times the inventions are really very complex actually, that point of time the agent or attorney must understand that invention actually, so these are some of the basics, I would say, from your filing to grant. And if of course, if you have all these things in place, that point of time your invention can get actually granted. Now what is the process as such? I would say you have an invention, you have identified a patent agent. Let me be a bit self-boasting, but you feel like I'm a good patent attorney, and you have to share a you have to file a patent. Now the very first step that you need to do actually, I would say, uh, that you need to sign a CDA or NDA, non-disclosure agreement, the confidentiality disclosure agreement. It has got lot of significance actually, that the what you are disclosing to me, I cannot use it actually, and I'll keep it confidential basically. It's not only about the patent agent. If you are collaborating with third parties outside India or within India for that sake, sign a CDA or the NDA first actually, and then only disclose your invention. The standard process for us to, when we have a client, that point of time is signing a CDA or NDA first, then only you share your invention with us. Once that invention is shared with us, that point of time we would evaluate internally whether it is novel, whether it is non-obvious, or is there an inventive step. Does it fall under Section 3? Does it have industrial applicability? If yes, then we can give you a patentability report. This is not a legal document. This is an internal analysis I, as a patent agent, or my team has done for you, and we are telling you that the patent can be granted as such. Thereafter, after confirmation from the scientist, we would start with actual drafting. Now drafting may take longer time actually, if the invention is really complex, there is no specific page number limit, honestly speaking. I have seen patents with 3 pages, and I have seen patent with 1,000 pages as well actually, it's specifically in the life sciences domain again. once we start with the drafting, as it is more of a techno-legal document, that point of time, a lot of technical inputs are provided by the scientists. And based on those inputs and claim drafting, so it's more of a collaborative effort of a scientist and a patent agent, the technology and the law part. See, I'm like, I did my LLB, but I'm not an advocate actually. But I'm more of a technical person, but I understand a bit of patent law as well. Like, so I understand your technology. I understand a bit of patent law better than you. I can draft a claim well based on the understanding of the invention actually. Thereafter comes, like, once you have the patent drafted, I am representing you at the patent office. You need to give me some kind of power of attorney. Power of attorney is a mandatory requirement if you are filing through a patent agent. In simple language, हिंदी में जिसे हम वकालतनामा बोलते हैं, that is power of attorney. You give a power of attorney that I can file a patent agent in the name of the scientist or that faculty or a startup basically. This is the beginning of the actual process of the, I would say, the patent filing as such. Hereafter, we would have patent filing. We have multiple forms, different kind of fees as well available for this. And at that point of time, we'll be filing these forms and submitting the fees as well. Now herein comes like, a trick, I would say, or I would say there is a difference in terms of fees for various stakeholders. For corporates, the fees is higher. For the corporates, the fees is higher. For the startups, individuals, the fees is 1/5 of the corporates, as well as recently in September 2021, for all the academic institutions, the fees has been reduced by 80%. Now, the fees which was earlier equal to the corporates, now it is equal to the individuals actually. And for those who are from the MSMEs, from the startups, for them, we are, ASSOCHAM IPFCs providing some kind of reimbursement scheme by the ministries, wherein entire the money spent on the prosecution or patent getting granted, that money gets reimbursed to you after patent getting granted. Also,
Hello.
yeah.
Hello, excuse me, sir. Sir, can we file a patent for any academic
Excuse
model?
me, we'll have questions at the end. Sir, Vijay sir, please continue. Shweta ma'am, please don't mind. We will have questions at the end. Please put your questions in the chat spaces.
Yeah. That would be really good. Also, Shweta, I feel I'm covering all the topics that you are interested in. Let me just finish the session, because it may happen that all your questions are already resolved in the later slides. Okay. Now, so the fees for startups, the MSMEs, as well as the individuals and educational institutions is reduced now. Like, so it is very less as I mean, it is less than the corporate as such. Okay. So the two fees that are mandatory at the patent office are the filing fees, which is just 1,600 rupees, and the request for examination fees, which is 4,000. These two fees are the ones which are mandatory for every application. The two fees that I mentioned are for electronic filing for individuals, academic institutions, MSMEs, and startups. Okay. And there are various forms which a patent agent can help you with respect to filing those forms. Thereafter comes a wonderful journey called as a patent prosecution. I saw one of the questions in the chat box: how much time does it require to get a patent granted in India? And honestly speaking, had this question been asked, let's say 4 or 5 years back, then probably I didn't have a proper answer. Anywhere between 4 to 8, 9 years as well, I would have said that. But now we have cases wherein, in fact, we got a case which got granted, I would say, from filing to grant, the case just required 6 months and 3 weeks. Now, why 6 months and 3 weeks, not before that? Usually after publication for 6 months, the patent cannot be granted. So the minimum time required, like, till 6 months it cannot be granted. And if I file today, the application gets published, let's say in 2-3 days, then I would say 6 months and 2-3 days, that may be the time limit actually, earliest actually, for us, it's 6 months and 3 weeks. We have to better that, I know, but it all depends on, I would say, depends on what kind of invention we have. Patent prosecution basically is a process, two-way communication between applicant, a patent agent, and the patent office, which is going to give you or which is going to grant you the patent basically, जो आपको certificate देने वाला है. That entire two-way communication is called as patent prosecution, right? Now, this is a legal term. We would go through that entire details with simple examples actually, in the further slides. Now I have told you that minimal time required, you can presume 7 months, is the minimal time. Average you can take 2 to 3 months. Beyond that, there are certain provisions for expedited examination as such. Okay, but then eligibility we need to check. There are a lot of details. Let's stick to the process basically here, and we can cover those expedited examination or the funding opportunities for IP granting and all that we can actually discuss in some other session answer. After patent gets granted, it has to be maintained as well. The term of a patent is 20 years from the date of filing. Now, when we have to maintain the patent, that point of time, we have to pay some renewal fees. Now, the fees for renewal of a patent from year 2, first 2 years, it is already included in the initial filing fees. Thereafter, the fees gets increased. First 4 years, like 3, 4, 5, 6. For the individuals, it may be 800 rupees, thereafter 2400. So it gets increased thereafter 4800, 7200 and 12,600. That way it gets increased actually. Yearly you can maintain that patent actually, I would say. But beyond maintenance, the most important thing as a startup, as a university, or as an individual, if you are really looking for the benefit of patent, is the most important, and wherein the real legal system is involved is the patent enforcement. Till this time, from signing an CDA, filing ideation to getting patent granted, a technical person, a non-lawyer can also do that, who is a patent agent. But enforcement parts is with judiciary, and it is more about litigation. What do you mean by enforcement? I'll tell you a simple case. I belong to a very small town in Maharashtra called Latur, if anyone has heard of it. For example, I have got some land in Latur, and I'm sitting right here in Ghatkopar, Mumbai, and someone encroaches on my land actually. That's a property that I have. Now I just can't wait, sit idle and wait that police would come and they would remove that encroachment basically. It is my duty to approach police to ensure that my land or my property is mine. Similarly, I have got a patent, it's my property. If someone else is using my patent, I have to go to court. It is my duty to enforce my patent and ensure that they are not using, or they are paying me the royalty for that. So enforcement is with respect to the judiciary. Enforcement has to be done by you as an individual. No third party. Once a patent gets granted, doesn't mean that no one can use. Others may use it, but you have to stop them, honestly speaking. Now, what if I have got a patent granted, but I can't manufacture the product? Let me share a simple, I would say, example. If you have watched the movie Three Idiots, actually, we have this wonderful character called Funsuk Wangdu. He has got a lot of patents, basically, right? And but he is least interested. This is what happens with the most of the academicians actually, or the startups even. They don't have the funds to, I would say, to manufacture that product. That point of time, they have this opportunity to license it out basically. So Chatur Ramlingam, like Funsuk Wangdu's friend, comes to him to get a license for the patent, because Funsuk Wangdu has got some patents and Chatur Ramlingam wants to commercialize. He can't do that. He has money, but he can't do that. But the legal rights, the idea is with Funsuk Wangdu as such. So that's how the patent system works. Getting a patent granted doesn't have anything to do with commercialization. I get a lot of inquiries like this. Sir, मेरे को patent recently grant हुआ. I got a patent granted recently. Can you help me commercialize it? No, your patent never gets commercialized. It's a blunt statement. I'll tell you how it works. Your product gets commercialized if your product has a value and that product idea is protected by a patent, then only your patent can be licensed out. What do you mean by that? I have this new product that I would say developed, and this product has got a commercial value now. If this product is protected by a patent, then only third parties cannot launch it or use this basically. Beyond that, if this product doesn't have a commercial value and you have got a smart attorney like me, you can still get a patent granted, but the product doesn't have a commercial value. Market value is zero here. That point of time, however number of patents you are getting granted, it is immaterial. You may not get the license, or I would say your patent cannot be licensed out at that point of time. That's why we generally call IP or patents as a negative right basically. And so this is a general process. This is a fundamental concept of patent. People get confused basically by patent grant. Patent grant doesn't give you any commercialization right. Even you yourself cannot commercialize your product if you have got a patent granted. What do you mean by that? Let us think of 5G as a technology wherein, let us say, Qualcomm is working. They have got some patents for that already granted. Doesn't mean doesn't mean that Qualcomm can have or launch that 5G technology in India directly. They have to go through the regulatory route of approval from TRAI to get that 5G technology launched. But what happens if Qualcomm has got a patent for the 5G technology related any of the services? That point of time, without Qualcomm's permission, no one else would be in a position to use that technology. That's how the patent system works. That's how the patent, I would say, from filing, the idea actually gets granted, maintained, as well as it is enforced. It is your duty to maintain it. It is your duty to enforce it. Let me quickly take you to some live cases, how we work with our clients. This is I would say the first step that I mentioned, signing a CDA, confidentiality disclosure agreement. Generally, we get the thesis, the research work from the academic institution, or the prototype model from the startups, or a concept idea from the startups after signing the CDA actually. Thereafter, we generate a patentability report. We share that report with the client. Actually, on the left hand side of mine, you can see a thesis. Actually, this is coming from a institute in Nagpur. Now, we got this thesis before it is published or before it is submitted. We file a patent for that. The day you file a patent application, your rights actually, I would say, you have got a priority over that invention. That means that is your invention now. Of course, it has to be getting granted to enforce your rights. But on the same day, you would get this wonderful receipt from Satyamev Jayate, Government of India, with date of filing, patent application number, applicant name, as well as the address, as well as the title of the invention and the fees paid. On the exactly same day, one day, you're getting that receipt. This receipt is like a proof that you have filed a patent application. Just need to remember this patent application number. After that, normally after 18 months from the first filing, the application gets published in a patent gazette, or what we also call as a patent journal. Now this is another invention that we had filed, and this got published after exactly 18 months. Now look at the filing date, 24th March 2017. 18 months, 24th September 2018. And the coming Friday after that, the invention got published exactly after 18 months. That's a normal process. Now we have this early publication process as well, wherein the inventions are getting published in. For us, the highest has been, we filed a patent application on a Wednesday and it got published on Friday, just by paying some extra fees. For the individuals, it is 2,500, 2,500, and for the corporates, I believe it is 12,000 or 12,500. But within a month, your application gets published, so you don't need to wait for this 18 months. Now, because of this early publication, actually, the time actually that is required for filing to grant has been reduced a lot in recent past. Okay, because remember, your examination only starts after the application gets published, although you file the so-called request for examination. Now, once you file, thereafter the application gets published, you have to request for examination. That means my application is filed, it is published. Of course, you can file the request for examination initially as well. Okay, but the request for examination is a mandatory step. And if you don't file the request for examination within 4 years after patent filing, your application gets lapsed. Now, once you file request for examination, thereafter they would come up with first examination report. This was for one of the clients, St. Xavier's College in Mumbai, Maharashtra. We had filed a request for examination. We got the first examination report for that. Now, what do you mean by first examination report? The first examination report would have patentability, like whether it is novel, whether it is inventive, whether it has any industrial applicability, whether the invention falls under section 3. How is it different from the patentability report that I prepared for you? The patentability report that I prepared for you as a client is my view about the invention. Patent office does it independently. Okay, patent office does it independently actually, and they would be the one who would be giving you actual examination report, and you would have to reply to that examination, just like your research papers. I would say, if you are aware of the concept of research paper, you get some comments from the reviewers and you have to reply. Okay, thereafter you have to reply actually thereafter. So you have 6 months time for the reply of the first examination reports. And now till this moment, everything can be done by a individual, or I would say a technical person. Filing you can do, request for examination you can do, examination report aa jata hai aapke paas. Thereafter, the moment, now yahan pe, this is not a technical stuff, this is a purely a techno legal stuff, reply to an examination report. Now, those inventors, just for the sake of saving the cost, have filed their patent application on their own. For sure, they would have to come to a patent agent, I would say, for first examination report reply, what we also call as FER reply. Once you submit the FER reply, there was a very interesting question asked in one of my sessions actually a few months back. Is it necessary that we get a first examination report? Can the patent get granted without examination? There is no objection basically. Yes, it is possible, but honestly, in my career, I have not seen that. Like, without any objection. That means that your invention is novel. It has an inventive step. It is as per the law, whatever requirements are there. It has an industriality. It doesn't fall under section 3. And even I feel so, as well as the controller feels so. Remember, the patent examiners and controllers are technical scientists, people like you. They are not lawyers. They are people like you actually, who would be evaluating the invention, and thereafter they would be providing the examination report, FER. Once I submit the FER reply, now herein probably without a after FER reply, if the controller is happy, that point of time, the uh, uh, the patent can get actually granted. That means FVR reply jab kiya. So this happened with us 3 times. I would say that at this stage itself, the patent got granted as such. Next, if the controller is still not happy, that point of time, we get this like I would say wonderful letter called hearing notice. Hearing notice is an opportunity wherein we get this opportunity to speak to the controller directly, to convince to the controller, because the same invention or same language may have different interpretation. We can tell the controller this is the actual interpretation, or this is the actual invention, this is the actual inventive step, this is why the invention is novel, this is why the invention doesn't fall under section 3, this is why this is the inventive step in that. Basically, hearing notice is an opportunity, and let me tell you, hearing is that stage wherein the lawyers are also allowed to appear for hearing. Till this time, only patent agents, lawyers are not allowed to file unless and until they are a patent agent actually, now at this stage lawyers can attend the hearing, as well as there is a specific rule under which even applicant or the inventor, that means a scientist, can also attend the hearing. And let me tell you, nowadays the hearings are also virtual. The hearings are virtual actually, in after hearing you have 15 days time to submit the response. That means whatever objections were discussed during hearing, जो भी आज discuss हुआ है, summarize it, put it as a written submission, give it to the patent office, and you would get this wonderful certificate, which would mean that you got a patent granted actually. This would include the patent number, the application number, the date of filing, the patentee's name, the date on which it got granted, the title of the invention, and this is the certificate. Now your patent is granted. I have helped you in terms of getting the patent granted as such, in terms of at least the Indian invention as such. Now after that you have to maintain it, you have to pay the renewal fees as well. As I mentioned, I am just concluding with this particular slide. I'll be happy to take, of course, the questions, but I like to conclude with this particular slide as such, which is about the movie Three Idiots as such, and wherein we have this scientist actually, Gopal. Okay, I have a question here, and I've got an answer as well. How many patents did Ranchodas Shamaldas Chanchad have?
3,000.
And the answer someone mentioned, yes, Makran, you got it there. Ranchodas Shamaldas Chanchad had 0 patents. It was Funsuk Wangdu who actually had 400 patents in his name. And so this is a tricky question actually, but yes, 400 patents for Funsuk Wangdu, not a single patent for Ranchodas Shamaldas Chanchad. Thank you so much. It was, I hope in a short time that was allotted to me, I'm in a position to make a justice to the the topic. Of course, it's a very I would say big getting a patent granted from filing. It's a big process. A lot of things are involved. In fact, for the patent agent exam training, we almost had, I would say, more than 40 hour sessions on the same topic that we actually did. But then I feel at this point of time, as basic, this is something which I would like to tell you, and I look forward for the questions. Thank you. Over to you, Hemang.
Thank you, Vijay. I mean, the feedback in the chat box is absolutely wonderful. I think at some point of time you should go through it. The truly informative seminar, and everyone is very well engaged. So I'll start in the chronological order, meaning start with the question received earlier upfront. Dr. Anish Gupta asked, it's more of a procedural question. While we can apply for online, because the patents are applied online, can we do away with the digital signature? Is there an alternative to that?
I'm sorry, Hemang, but I couldn't hear the question.
Yeah, this is Dr. Anish Gupta. Can I say my question?
Yes, please. Yes, please. Yeah.
Yeah, my question is that while filing, I have already filed one patent and I've got it published. But the problem what I faced was if I am helping my friends out, we need to have digital signatures while we are doing an online filing. Can
That is
it
so true.
be,
Yeah.
can we do away with that digital signature?
So, Dr. Anish, we have two procedures in India for patent filing. Physical filing at the patent office, respective patent office, of course, paper copies. Electronic filing definitely requires you the digital signature as such. Honestly, the physical filing itself is also a electronic filing because once you go to the patent office, वहाँ पे जब आप document submit करते हो, there is a person sitting here there who would be filing electronically filing it for you. Okay, you can't go away with that digital signature part. That's mandatory. Yeah.
All right. Thank you very much.
Yeah.
So I'm going to be grouping some
Excuse me, sir.
also based on what has been received. So Tejaswini Singh and Shweta Bhatti ask I would say a very similar question. So one is, can we get our research questionnaire patented or academic models?
I'm so sorry, Hemang, but I am not able to hear it properly.
Okay.
Hemang, your voice is not that clear. If you
Yeah,
can.
yeah.
Yeah, sorry. I'm Anirban, I'll paste it for you.
Sure.
Hello.
Sir,
Hello.
can I ask a question?
Yeah, why don't you ask
Meanwhile,
Hemang
yeah.
place the questions, please?
Yeah, Shweta.
So, sir, I wanted to ask, can we get our research questionnaires also patented?
Research questionnaires cannot be patented for sure. What it lags is the industrial applicability, basically. The research questionnaires, or I would say anything which is more of a literature or artistic kind of thing would go as a copyright and it won't go as a patent, basically.
Right, right. Okay, sir. Thank you.
Yeah.
Hi, sir.
Hello.
Actually, I'm having
Vijay,
three questions. First, I'm confused between a trade secret. Actually, I have created I made my own hair oil and pain relief oil. So I'm confused between to make it as a trade secret or I should make it patent. I'm not getting proper guideline for this.
Yeah, Arpit, I think that's a very interesting question, and this is like a dilemma most of the early stage innovators have actually, if unfortunately in India that we don't have a specific trade secret law. It is protected under the Contract Act actually, So we always recommend to go for patent filing because it is like protecting your invention legally, basically, instead of because the enforcement of the contract, and there are a lot of things with respect to the trade secret, and as I mentioned, there is no specific trade secret law in India. So the advantage of trade secret is, honestly speaking, is more about having your invention only with you for longer period of time. Patent is just for 20 years. That's how you could actually see it as, but then do we have that infrastructure as an organization or as an individual or as a startup or as a university that you keep it as a trade secret, basically, and when we think of 20 years as a timeline and compared to trade secret, let us say for 50 years, we also need to understand that probably after 10 years or 15 years itself, your product or technology may be obsolete actually, right? And it's so trade secret itself may not be in a position to help us. I hope that at least partly answers your question, Arpit.
Okay. Adding to this only, actually, I have most of my ingredients which are naturally available. So I'm taking that thing as raw, but few ingredients I'm using of some company. So in this case, patent, what would be a question mark with the patent?
Absolutely. Arpit, that makes sense. Although you are getting the ingredient source from third parties is absolutely fine. But we also get the similar inventions. We don't disclose the brand names of that or the original names of those. What we mention in the patent document is actually a generic name, let us say. Actual content, the chemical name of that particular product, rather than putting the brand name. That way, who is your vendor, where are you sourcing it from, which grade, that would never be required to be disclosed.
Okay. And so do we need to mention that the technique which we use to make that oil in patent?
That all depends, Arpit, what kind of inventions you are looking forward to.
Heating time. I know that the weight, I need to mention that this is the weight of this particular ingredient I have used, but the heating time and how to prepare process.
Yeah, Arpit, honestly, and this is not only for Arpit, but for all the researchers. See, the data that is required to be disclosed in the patent document depends on the claims only. What you are doing as a PhD actually, or let us say research, master's research, that point of time you may be having a lot of data, but the data that is required to be disclosed in the patent document is just restricted to that would be dependent only on the claims, and it is not necessary that everything need to be disclosed. So that's where I believe the real challenge of a patent agent or patent attorney is, yeah.
Sir, we'll go to the next question.
One more point on this.
Mr. Arpit, then others will not get a chance to ask questions.
I can understand.
Request you
Mukherjee
to.
Sir, just one. It will help everyone also. So, like you have answered this in case of oil ingredient, but if I talk about in case of product, software product, in which I am using some something from some repositories of some official like Google or something. So in that case, can I get patent?
Arpit, this is your last question, and I answer it bluntly. No, softwares are not allowed. Yes, then we can move on.
Thank you.
Sir, I'm asking a question from Mr. Anand Banthia. Sometimes companies or people bypass or find ways to go around patents. What things or points or steps to be planned to make patents stronger or effective?
Thank you so much, Mr. Anand, for asking this question. Actually, and exactly, I think I had that one particular slide of snakes and ladder, and kind of I self-boasted, Vijay Shivpuje ka naam likh diya. You need Vijay Shivpuje to get your patent granted. Honestly speaking, your invention need to be understood by an agent or expert. Actually, it's not about getting a patent granted. It is also about how much protection you are getting for your invention. And only someone who understands the technology, who understands the legal part, would be in a position to answer this, Anandji. This is not something like there are specific pointers or specific things I can do to make it strong. At the end of the day, patent office is there to grant you patent, actually, but what is available in the public domain, is it novel, does it have inventive step, industrial applicability? Based on that only it would be getting granted. But definitely you need a smart patent agent or attorney who can understand your invention and the legal part, especially in that domain. I think that's what my answer is. Yeah.
And I have a question, please.
Sir, we'll just go through the questions in chat that people have asked.
There's one question in the Q&A section. Please take that question. Only one question there.
Okay. So I'm going by order.
Q&A, there's only one question, sir. That's it.
Sure. So on the Q&A, but I will go in order of chat. Sir, Ms. Sneha has asked, what is a provisional patent?
Yeah, so Sneha, provisional patent is just based on a hypothesis wherein you have not executed the plan. Actually, you haven't got any research data, or you haven't actually performed that invention. But as a hypothesis, as an idea, you are trying to file a patent. But within 1 year, you have to execute it, come up with the data, and thereafter file a complete application. Provisional, unless complete is filed, doesn't have any value. Yeah. Yes, Sneha.
I have a question, please. Mr. Vijay?
Okay, please, sir.
Yeah.
See, if my invention is already implemented in a it's a small component. Basically we are electronic equipment manufacturers, nuclear instrumentation. Now there's a subcomponent, subsystem, we developed, and that's an invention newly developed, and we have implemented in the product. Now, but we have already put it into the market, say. So is it still the patenting can be is it eligible for that?
No, absolutely. So this
You
is
should not have put it
exactly
to the
what
market.
No,
Before.
absolutely. You can't get it because the moment it is in public domain,
Yeah.
like it is marketed. The way I mentioned, you don't need to disclose. You can't market it as well before filing a patent.
We have not published any paper, of course, but
absolutely. But it is in public domain.
Yeah.
Is the product available in the public domain? Can I access it? Can I get it?
Yeah, it is available, but we cannot apply for patents either.
No. So that's what I said.
Not, yeah.
When we think of absolute novelty, it's just not about research paper. It's about social media. It's about market. Anywhere, if it is available, then there is no novelty and you can't get it granted. Sorry.
So before we put it to the market, we should apply.
Absolutely. And in fact, that's the very first step that you need to follow. Yeah.
Okay, thank you.
Sir, Dr. Krishna Samarpathy has asked, what is the requirement of the non-obviousness?
I think I have already covered this, and it is about the inventive step. Let's move on to the next question. Yeah.
Sure, sir. Sir,
Mr.
any
Vijay,
kind
sir,
of draft available
I
for
ask
techno-legal document?
No,
Hello.
not exactly. I think this is again coming from Arpit. Arpit, there is, because every
Hello.
invention is different. Every invention is different. You would have a different patent draft for each invention. Actually, there is no standard format. Yeah.
Can I ask something, Mr. Vijay, sir?
Okay, please ask it.
Hanji, sir, I am working on a research article, and if we draw some measures for that problem from any secondary sources and build a model from any and doing some addition by my part of uniqueness, so can we patent that particular model?
For me, Shweta, this is very vague question. I think I need to discuss this in detail one-to-one rather than taking it here, because this is very vague. I can't answer this. I'm just sharing my phone number in the chat box. If required, you can get in touch with over a call and we can take it ahead. Yeah.
Okay, thank you so much, sir.
Mr. Ankur Rajput asks, please share details on how to find the right patent attorney who actually understands the space and product for which the innovation has been done.
Identifying the right kind of patent attorney, that's what the question is, right?
Yes, sir.
The Patent Office has a list of patent agent on their website, along with their technical expertise as well. Beyond that, you can just search for SIPP, that is a scheme by Indian Patent Office. They are the patent facilitators for the startups. And there are specific domains like electronics, someone mentioned, computers, biotech, telecom, like the life sciences, the pharmaceuticals. So there are specific experts in that domain. Along with their phone numbers and email addresses, it is available. If required, for sure, the ASSOCHAM team can share it with you as well. Like, we'll share it with ASSOCHAM team. Yeah.
Sir, Suma asks, can technology transfer of Indian patent has only been filed but not yet published, be done to, let's say, a US company?
That's a tricky question, I would say. At the end of the day, if you are transferring the technology to a country wherein you have not protected your invention, then probably there is no value for that. Someone else can very easily copy it. Like, wherever you are transferring. So how it works basically, if you want to transfer the technology or sell the product, let's say in 10 countries, you will have to file the patent in all those 10 countries. So whatever are your potential business markets for the product, for them you will have to file the patent. Yeah.
Sir, Mr. Kalyan Sundaram has asked, sir, I filed a patent application for my innovative of high pressure pump 5 years back, but till date the patent not granted. So what to do to speed up the process? How to protect the rights till I till I get the grant of patent?
I would say, you can get in touch with the controller, honestly speaking, to facilitate it, like, kahan pe, what is the lacuna, or even your agent or attorney, whoever has filed, can actually kind of expedite it, and but then you don't need to worry about the rights, because the day your application was published, wahan se aapke rights hote hain, and you can, but only thing is you can enforce them only after the patent gets granted. Yeah.
Okay. Sir, Dr. Krishna Samarpathy asks, what is your personal experience with the difference between the national and regional patent process? I'm not able to understand the question. So,
Yeah,
I mean, are they meaning regional offices of the patent office or the central office of the patent office, or is it between countries? So
I think this is a bit confusion actually, because we have 4 patent offices in Mumbai, Delhi, Chennai, and Kolkata. But there is only one office, just for the ease of I would say working. We have got 4 offices, but it doesn't mean ki if you file a patent in application in Kolkata, it gets granted easily, and if you file it in Chennai, it doesn't get. Frankly, the way it works is, if you file a patent application in Kolkata, it is actually transferred to some officer or controller in Mumbai or Delhi or Chennai, and that's how it is prosecuted actually. So there is no basically difference in terms of the different patent offices. Yeah.
Sir, Miss, I think Pragya Milind, is asking, if an individual has filed an application for patent and get it published, can more individuals can be added as owners of the patent? I mean, I think it's a obvious question, but I thought that,
Yeah.
Okay.
Of course, it can be added with there is some additional requirement in terms of fees, and there has to be some rationale actually, because generally when you file a patent and when it gets granted, many times there is a difference in claims as well, and if there is a contribution by an inventor who was unfortunately not included at the initial stage, that can be added. That there should not be any issue as. Yeah.
Sir, Suma is asking, can you throw some light on technology transfer or licensing of Indian patent?
I think we can actually have an entire session on licensing and technology transfer. But as I said, it is very essential when specifically in the context of the universities and startups. See, it's not the IP that gets transferred. Okay, it is always the product that need to have value. If this fundamental we understand कि हमारा जो research है वो product अगर market में जाने वाला है तभी उसको value मिलेगा. I think this is my message, and we can actually ASSOCHAM team can have or L2 Pro team can have a session on tech transfer for sure. Yeah.
Sir, how to check if an application has been published? Because it takes some time for the publication of the.
Yeah. So Indian Patent Office has this iPair site, जहाँ पे आपको you will come to know whether what's the status of your application at any point of time. If it is published, it would be in public domain, all the forms, details, and all. If it is not, it would show it as a pending status, not yet published करके. Yeah, is there in the Indian Patent Office.
Okay.
Can I ask one question? This is Rajesh.
Sure. Yeah, please.
All right. So thank you. So first of all, thanks to the ASSOCHAM for organizing this wonderful, the enlightening session. It is really helpful to us. And thank you very much, Vijay, for the wonderful presentation. Really helpful. So my name is Rajesh, and we are from Rajesh Laboratories. We're also happy to say that we are the first batch winner of ASSOCHAM ICT Startup Award back in 2017. So my question is, so we have the patent already granted, or it is applied for any patent that is granted. So when we do the improvements, based on what parameters should we decide to go for either an improvement patent or a new patent altogether?
Yeah, that's I think your question itself answers it actually. Would you call it as a simple improvement? If it is an improvement, definitely you have to go for patent of addition. Remember one thing, your granted patent is now a prior art for your next invention. If your new invention is novel, novelty may not be an issue because you are saying improvement, right? The issue may be predictability. The improvements that you are doing, are they predictable? If yes, then go for patent of addition. If no, go for an individual separate patent. Yeah.
All right, thank you so much. And would that impact, let's say that if you apply for an improvement patent, the priority, would that be linked to the original patent or from the date of filing of the improvement?
Absolutely. The data that was there in the first patent, for that the priority would be the first date. The data that you improve, like you add at the time of improvement patent, or what we call it as a patent of addition. For that data, the priority would be the day you file that patent of addition. What does that mean actually? That data for improvement patent need not be disclosed before that date. That is important. Yeah, Rajesh.
All right. Thank you so much, Vijay.
Harishji, I did not see your question in the chat box. So if you have a question, please do ask that. Harishji may not be there. If anybody else has some questions, please do ask. Otherwise,
Yes,
we can...
so myself Praveen Kumar. So if any PhD thesis has already published, so is there any provision to file the patent?
Nice, sir. It's not possible because that's what I mentioned. Aapko, you file a patent first, thereafter do whatever you want. You commercialize it, you publish it as a paper, you submit your thesis. The moment you do anything, then as I said, even आपने अगर LinkedIn post किया है, this had happened with one of our clients actually. LinkedIn पे post कर दिया, we have got this results and all, and that was actually as a prior art cited by the examiner as such. तो कुछ भी नहीं कर सकते. You file first file, and thereafter whatever you want you do.
But the candidate, they are not aware or even not knowing about the time taking for the patent granting.
Absolutely fine. If you file it today, next day say आप कुछ भी करो, there is no concern. Patent getting granted has nothing to do with your later publications, na?
Okay, so first of all, we have to apply the application, and then we may go for the further course of action.
Yes, प्रवीण जी, मैं आपको एक सिंपल टर्म बताता हूँ, आपको पता चल जाएगा उससे. Like it is a advance booking of your invention. मतलब मैंने ना एडवांस बुकिंग कर लिया, मेरे नाम पे है. अब जिसको जो करना है वो करने दीजिए, मेरे पास राइट्स है उसके, मतलब मैंने फाइल करके रखा. Does that make sense?
Yes. Thank you very much.
Yeah.
Hi Vijay, this is Vijit here.
Yeah.
I have a quick question. Just wanted to know if the patent can be filed in the name of a company instead of a person. Can that be done?
Absolutely, that can be done. That's what I said. In fact, that's the way it has to be. Because when an employee is working with you, Abhijit, that point of time, although the invention is from that particular, the intellectual is from that particular person, but he is doing it as a part of the employment. Basically, you're paying him for that. Similarly, for the university, if a professor of that university is working on a research as a part of employment, that research is assigned to the university or the company itself. That's the basic fundamental. But there is the other way down. A company cannot file without a single inventor. That means a company, the applicant, assignee would be a company, but there has to be at least one single inventor, individual human being as inventor need to be put in.
Okay, fantastic. Yes. Sorry if I've already told that. Your voice was breaking, so I could not hear. Thank you.
Thanks.
Thank you very much.
So, Hemang, would you, if your connection is good, maybe you would like to, give your vote of thanks and get the webinar to a close.
Sir, can I have one last question?
Okay, last question. Yes. Thanks.
Sir, we have heard, and I think it may be conception or misconception, that if we apply patent individually without taking help of any of the agency, in majority of the case, it is not get accepted. Is it so?
I have a different experience rather. Like I'll tell you, honestly, the patent officials, the examiners and controllers, they are very much helpful for those individuals who are filing their inventions as such, they are actually helping them getting it granted in terms of understanding or in terms of the legalities and all, actually the formalities and all. This is a misconception, but as I mentioned, in few cases, if you're filing on your own, it may not get granted, not because you have filed as an individual, but it would be based on the quality of the application that you are actually filing. In terms of the writing skills, in terms of the drafting skills, in terms of, I would say, the claim language and the way you are replying, so based on that, it may not get granted. Does that make sense?
Yes, sir. Yes, sir. Thank you. Thank you very much, sir.
Yeah. Yeah.
Yeah.
Okay. Vijay, this was an amazing seminar. I hope you can hear me. If
We can hear you. Yeah.
Okay. Yeah. See, Vijay is sitting in the.
Could I have a question, please?
Okay. No, actually, we are almost at the end. We have overshot our time by 22 minutes.
I've already shared in the chat. Maybe if you could look into it. Just the last one.
Okay. Last one. Okay.
Vijay, your call. One last.
Yeah, sure.
Thank you so much, Mr. Vijay. You took one of the questions earlier. Thank you for answering. I will connect with you offline as well. Just want to know, for a product which is yet to be commercialized, but the prototype is ready, and what shall be the fees for the fast tracking of this application so that the patent could be granted faster in order to support the go-to-market?
Yeah, so Ankur, firstly, it's not about just the fees, but there are specific criteria only for the applicants. Only then they are eligible for expedited examination. So if you are a registered startup, you are a DPIIT registered startup, you have that DPIIT registration number, or if you are a MSME, if you are individuals with a single female applicant, or if you are a government institute or government department, in that case only you can go for the expedited examination. The fees difference is not much actually, I would say, only fees differential is with respect to the publication, the request for examination fees. The exact fees is so for 4,000 for individuals is 4,000 for the request for examination. I think it is 3 times for the expedited examination. That's the only difference. But I would say it all depends whether first important criteria is, are you eligible to file that for that expedited examination? Yeah.
Perfect. Thank you so much for answering. I'll connect with you offline as well.
Perfect. Yeah. Thank you.
Thank you.
Thank you, Vijay. This was really a very well-conducted webinar, very insightful. And as you can see, everyone really appreciated. You look at the chat box, you look at the feedback that they're sharing. So thank you so much. And truly appreciate your energy and the insights that you shared. Everything you shared was practical. So on behalf of our entire team at ASSOCHAM, at L2 Pro, and of course all of our attendees, thank you, Vijay. Thank you as well to my dear colleague Agarwal for moderating the Q&A. And of course, most important are the attendees, right? Because you took time out to learn this really powerful, impactful topic. So kudos to all of you. And that's it from us today. For today. Thank you so much.
Thank you. Thank you, everyone. Bye.
Thank you.
Thanks to the over 200 attendees who attended.
Especially the question answer session.
Thank you very much. Thank you, Anvita. Very nice webinar. Very nice talk. Excellent.
We will have a recording of this video in case somebody has missed it. Thank you.
I see. Yes. Okay.
Thank you.
Thank you.